Uti Possidetis is a principle of international law that, in the context of decolonization, dictates that newly independent states should inherit the administrative borders of their former colonial territories, aiming to preserve stability and prevent disputes. The essence of the principle lies in its primary aim of securing respect for the territorial boundaries at the moment when independence is achieved. Such territorial boundaries might be no more than delimitations between different administrative divisions or colonies, all subject to the same sovereign. In that case, the application of the principle of Uti Possidetis resulted in administrative boundaries being transformed into international frontiers in the full sense of the term. The term Uti Possidetis was derived from Roman law. It is a shorthand for the Roman maxim Uti Possidetis, ita Possidetis, which literally means as you possess, so may you possess. It is an interim remedy granted in the initial stages of litigation over immovable property. In this context, Uti Possidetis was a remedy that sought to preserve the status quo. It granted the litigant holding the disputed property a legal right to continue such possession during the pendency of the litigation, thereby preventing forcible eviction. Crucially, the right granted to the possessor was always a temporary one. Uti Possidetis always preceded a more detailed determination of the property claim on merit, and only operated until the dispute over legal title was finally settled. In the context of international law, the principle of Uti Possidetis was first developed among the Spanish colonies of Latin America in the 19th century and later accepted by the Organization of African Unity in its 1964 Cairo Declaration. The African Union has confirmed its adherence to the principle of Uti Possidetis in Article 4b of its 2000 Constitutive Act, which states that members of the African Union should respect borders existing on achievement of independence. The principle of Uti Possidetis imposes a limitation on the exercise of the right to self-determination by colonial people. They are to maintain colonial frontiers even though they were artificially drawn by the colonial powers, without any consideration as to ethnic or historical tradition of the people or peoples living there. This limitation has been confirmed in United Nations General Assembly Resolution 2625 by African leaders in the 1964 Cairo Declaration and the case law of the ICJ in the case concerning the frontier dispute Burkina Faso v. Republic of Mali. The principle of Uti Possidetis is not a rule of jus cogens. By mutual agreement, interested parties are allowed to depart from it. This was confirmed by the ICJ in the case concerning land, island and maritime frontier dispute, El Salvador v. Honduras, Nicaragua intervening, in which the ICJ stated that the parties involved were allowed to modify the existing frontiers through an exchange of territory. Following from this, it is clear that existing boundaries are not immutable and may be changed, but the consent of all parties concerned is required. Uti Possidetis has also been applied outside of the colonial context. More recently, the Badinter Commission, which was established by the EU in order to deal with problems arising from the disintegration of the former Socialist Federal Republic of Yugoslavia, in its opinions 2 and 3 relating to self-determination and the frontiers of new states, stated that the internal boundaries of the former Yugoslav republics should become international frontiers protected by international law. The principle of Uti Possidetis has been rigidly applied by the ICJ in the context of post-colonial border disputes. In the frontier dispute case, Burkina Faso v. the Republic of Mali, the ICJ based its judgment on the principle of Uti Possidetis, to which both parties referred. The court held that the principle of Uti Possidetis was of general application with regard to the determination of borders for all newly established states in Africa, not just to states located in South America. Further, it held that the recognition of the principle of Uti Possidetis by the new African states, as evidenced, inter alia, by the Cairo Declaration, showed that it had become a principle of customary international law. Although the principle of Uti Possidetis has prevented many territorial disputes, it has also been a source of many major armed conflicts between African states, such as Somalia and Kenya, Ethiopia and Somalia, Togo and Ghana. States can always adjust their frontiers by an agreement, and in some circumstances the principle of effectiveness may prevail over the principle of Uti Possidetis. In the Nicaragua v. Honduras case, the ICJ considered that the Uti Possidetis iuris principle might in certain circumstances, such as in connection with historic bays and territorial seas, play a role in a maritime delimitation. When considering the application of the principle of Uti Possidetis iuris to maritime delimitations, intertemporal law should be considered. It seems logical to consider that the principle is not applicable to marine spaces which were unknown in the colonial period. Therefore, the principle will have no role to play in the delimitation of the exclusive economic zone, which was crystallized in the post-colonial period. If the principle of Uti Possidetis iuris can be applied to the delimitation of the territorial sea, an issue arises with regard to the extension of the delimitation line, since there was no agreement on the maximum breadth of the territorial sea in the colonial period. Currently, the maximum breadth of the territorial sea is 12 nautical miles under Article 3 of the United Nations Convention on the Law of the Sea. However, it is not suggested that the delimitation line on the basis of the principle of Uti Possidetis iuris will automatically extend until 12 nautical miles.